The Court of Appeal read out the determination of the Supreme Court today in relation to several matters which had been referred to the Supreme Court by the Court of Appeal on the interpretation of the Constitution. The Supreme Court had determined that the Parliamentary Select Committee, which examined the impeachment motion against the Chief Justice, had no legal power or authority to come to a finding adversely affecting the rights of a judge.
The petition filed by Chief Justice Dr. Shirani Bandaranayake challenging the findings of the Parliamentary Select Committee was to be taken up before the Court of Appeal today. Many opposition parliamentarians gathered at the Supreme Court complex in Hulstorf. The petition filed by the Chief Justice was taken up before a bench comprising of Justices S. Srikantharaja, Anil Gunaratne and A.W.A. Salam. Before taking up the petition, the Court of Appeal read out the determination of the Supreme Court. The Supreme Court interpretation states that in a state ruled by a constitution based on the rule of law, no court, tribunal or body has authority to make a finding or a decision affecting the rights of a person unless such a court, tribunal or body has the power conferred on it by law to make such findings or decisions. It adds that such legal power can be conferred on such court, tribunal or body only by an act of parliament which is law and not by standing orders which are not law but are rules made for the regulation of the orderly conduct and the affairs of the parliament. The Supreme Court shows that Parliament, by standing orders, provide for all matters relating to the presentation of the procedure for passing resolutions. The matter relating to proof, being matters of law, also will have to be provided by law, and the burden of proof, the mode of proof, and the degree of proof also will have to be specified by law to avoid any uncertainty as to the proof of the alleged misbehavior or incapacity, without leaving room for the body conducting the investigation to decide the questions relating to proof according to its subjective perception. The Supreme Court points out that the preamble to the 1978 Constitution assures to all people inter alia the independence of the judiciary as the intangible heritage that guarantees the dignity and well-being of the succeeding generations of the people of Sri Lanka. The Supreme Court says that on the 20th of June 2001, the late Andro Bandaranayake, the then Speaker of Parliament, had pointed out members of Parliament may give their mind to the need to introduce fresh legislation or amend the existing standing orders regarding the motions of impeachments against judges of the superior courts. The constitutional interpretation was made by a three-judge bench of the Supreme Court comprising of Justices Nimal Gamini Amaratunga, K. Sripavan and Priyasad Deb. A group of attorneys, including President's Counsel K. Kanangeeswaran, S. L. Gunasekara, President's Counsel G. Alagaratnam and President's Counsel Shibli Aziz were present at the Supreme Court representing the petitioner.
The Supreme Court has determined this Select Committee appointment is unconstitutional, it is in violation of the Constitution, and the Court of Appeal has now issued notice on all the respondents returnable on the 15th January.
The Supreme Court is the sole authority to interpret the Constitution. No one else has the judicial power to interpret the Constitution. It is clear that the decision and the report of the Parliamentary Select Committee is void before the law and has no power. Meanwhile, lawyers appearing on behalf of parliamentarian Vijitha Herath and R. Sambandhan, members of the Parliamentary Select Committee, were present at the Court of Appeal in connection with the petition filed by the Chief Justice. The three-judge bench refused to grant permission to hear two petitions filed against the petition filed by the Chief Justice. The petition filed by the Chief Justice will be taken up on Monday. Vijitha Herath and R. Sambandhan appeared before the Court of Appeal and said that they would not file objections. Accordingly, the petition will be taken up on Monday. A notice was issued to the Attorney General to appear before court and present facts to the court if he wishes to do so.
කරුණු දක්වන්න කැමති නම් ඇවිල්ලා කරුණු දක්වන්න කියලා අධිකරණය නීතිපතිට නොතිස් කරලා තියෙනවා.